Now more than ever, transportation business owners need industry experts at every stage in their company's life cycle. We bring them to you in the hot seat.
Welcome to In the Hot Seat with the Tenney Group. I'm Spencer Tenney. It's good to be with you. Today we have a fantastic guest with us, Marc Blubaugh from Benesch Law Firm. Marc, it's good to be with you.
Delighted to be here, Spencer. Thanks for the invitation.
So, getting started, just give us 30 seconds, who you are and what you do at Benesch.
Sure. I'm a partner with a law firm, which is a national law firm, full service, with offices across the country. I serve as the co-chair of our firm's Transportation and Logistics Practice Group. So we are a cross-office, multidisciplinary practice group that solves problems for clients who are either providers of transportation and logistics services or the commercial users of those services.
I like it. All right. You ready for the heat?
I'm ready.
Let's get to it.
All right.
All right. What is one court decision that transportation business owners should be aware of, one recent one that they should be aware of right now?
Sure. The case I would mention would be the New Prime versus Oliveira case. This is a case that the U.S. Supreme Court issued a decision on back in January of this year. And it's notable because not many transportation logistics cases get to the U.S. Supreme Court. This is of particular importance to the trucking industry. The case involved a claim by an independent contractor, an owner-operator of New Prime, that he was misclassified as an independent contractor when he was in fact an employee, and claimed that he was entitled to certain minimum wage payments. The agreement that he had with New Prime included an arbitration provision that required him to arbitrate any such dispute rather than go to court. So when he went to court, New Prime naturally asked the court to stay that litigation pending arbitration. Mr. Oliveira said, well, that provision is unenforceable under federal law, that there is an exemption in the Federal Arbitration Act for transportation workers involved in interstate commerce under a contract of employment. The lower courts agreed with Mr. Oliveira, and the U.S. Supreme Court also agreed with Mr. Oliveira that that provision was unenforceable at the end of the day. So the practical implication for motor carriers in the industry is that they can no longer rely on federal law to enforce these arbitration provisions that are in their independent contractor services agreements with their independent contractors. They may be able, however, to rely on state law to enforce those provisions when they run into those disputes, depending on the language of their agreement, which of course is always the starting place.
Wow, that's interesting. So on the regulatory side, what's one thing that's on the horizon from regulations that, again, you think that our audience should be aware of that's coming on board?
One that is underappreciated, I think, is it's actually international regulation. The International Maritime Organization has imposed a low sulfur mandate that is going to affect ocean carriers starting January 1st of 2020. You may say, well, what does this have to do with trucking or domestic transportation? But the reality is that this mandate is going to drive up the cost of diesel because of the supply and demand issue. Some project it may increase as much as 25 cents a gallon. One of the reasons that's important is that the leading indicator of motor carrier bankruptcies has been a spike in diesel costs over the years. So a lot of carriers are going to face some challenges in the year ahead as their thin margins become even thinner.
That's a lot to take in. We got a couple more questions though. What about technology? What is a technology development that's affecting the legal landscape right now that we need to know about?
Yeah, transportation and technology is fascinating to me. It's one of those industries. I was presenting with a CIO at a conference earlier this year, and he made the observation, which I think is very true, that in the transportation world, we've got the full spectrum. You've got the highest high tech on one end, but you've got literally zero tech on the other end. And as these companies move from the people and paper-based systems to more sophisticated automated systems, there are all sorts of legal issues that pop up, one of which, of course, is data security and data privacy.
So what would be a threat to trucking business owners right now when it comes to plaintiff personal injury bar?
The plaintiff's personal injury bar has gotten increasingly sophisticated in recent years. Even about 2 weeks ago, there was a $280 million judgment entered against a trucking company. Amazing. These numbers are staggering. And the plaintiff's personal injury bar has collaborated. They have become increasingly sophisticated to understand the business, and they capitalize on what they call the reptile theory, which is a strategy they use supposedly to activate the lizard brains in the jurors to create a sense of fear so that the jury is motivated to do something to make the public safer. The plaintiffs identify a safety rule or regulation that they think is clear and unambiguous. They get the safety director to admit that there was a technical violation, and they hope that the jury will punish the motor carrier as a result, and sadly, it works frequently.
I'm telling you, that is crazy. I got one last
right.
wild card for
Yes.
you. So one of the things that we do a lot of networking lunches at Tenney Group, and a little icebreaker that we do is called Fun Facts. So the deal is, what is one thing that you could share about yourself to our audience that we couldn't already find out by looking at the Benesch website, your LinkedIn profile, or
right.
Facebook?
That's a tricky one. Let's see. How about this? Years ago, I had the chance to have lunch with Barry Williams, who was Greg Brady on the Brady Bunch, and I had a fun lunch. That's an unusual fact there.
That is a fun fact, and it has been fun here. I thank you for sitting in the hot seat. Appreciate you, sir.
Thanks, Spencer.
Again, I'm Spencer Tenney. Thank you for being with us. We'll see you next time.